Oyez, oyez, oyez. Anyone having business before the King's Justice, the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Honorable Justice Hennessy presiding. Please be seated.
Good morning, all. Just before we start, the clerk advised me that Mr. McIver handed to her a compendium. Is Mr. McIver here or Ms. Brack? I see that it's mostly case law, but not all case laws. Is it your intention to make this lettered exhibit?
Yes, it is.
All right, it would be Exhibit C then.
Thank you.
Thank you for that. And Mr. Worm, just give me 1 second to get my screen up. Ready to go.
Anine, bonjour. Good morning, Your Honor. Your Honor, before I commence, I just want to take a moment to acknowledge two Robinson Huron Treaty Anishinaabeg representative plaintiffs who are in the room, and they're seated in the galley at the back. There's Mr. Peter Recollet and Mr. Roger Daybuch. I would be remiss as well if I did not extend our thanks and express the gratitude on behalf of the entire Robinson Huron legal team to our friends in the room here for giving their consent to our intervention in this important case, and we do thank them for that. I expect to be brief. I have two matters simply to cover before my learned friend, Ms. Boise-Parker, assumes the podium. As one of only two First Nations lawyers in the room, I just wanted to stand and to make some remarks that in listening over the past week and what I anticipate will be said next week that I think are important. Specifically, I want to remind everyone what the Anishinaabe perspective entails. We've heard a lot of references to, and particularly the principles of respect, responsibility, reciprocity, and renewal. These principles seem to be treated as simply a mantra: respect, responsibility, reciprocity, renewal. But we say these principles are more than mere T-shirt slogans, but they have real meaning. They have content and associated expectations for Anishinaabe peoples. These principles come from a different cultural perspective, a different cultural lens, if you will, which among other things entails a different way of interacting and engaging with the world and all its inhabitants, whether human or non-human persons, other than human. These principles permeate Anishinaabe lives, especially at the council fire. Leaders, as stage one evidence shows, were expected to embody these principles. And the relationships and alliances relied on the manifestation and expression of the principles in speech and in actions. And those attending council fire were under the same obligations. People come together and discuss issues based on and reflecting what the principles actually entail. The fact that a council fire today may occur in a boardroom or a conference room is immaterial. The continuity of that process does not exist in the setting, but through and in the expression and performance of the Anishinaabe principles. What the Crowns need to do, in our respectful submission, is to participate, as William Robinson did, in council fire that is an expression of the trans-systemic alliance Robinson partly codified in the text of the treaties and in his diaries. In our respectful submission, the treaties at issue in this litigation cannot be understood without an acceptance of this. The Eurocentric perspective does not dominate the task before this honorable court, and yet much of what we have heard and what I anticipate we'll hear next week seem to assume or are filtered through the Eurocentric perspective or lens. Anishinaabe people, as with other Indigenous peoples, made the first treaties with the Creator and all the inhabitants of the world. And we heard about this during stage one, such as with Nanabush. These original treaties begat subsequent treaties between the original nations that inhabited this land, as we heard in stage one. When foreigners from across the ocean arrived, those treaty and alliance-making practices continued, and they continue today. And just because the treaty started to be entered into with those foreigners from far away, it did not and does not mean the treaties were understood from the Anishinaabe perspective as the foreigners understood it. Like with this lengthy history of treaty making, when the Robinson-Huron Treaty Anishinaabeg speak to the Anishinaabe perspective, it is and was, as was seen in stage one, about laws, protocols, values that have existed in some form since time immemorial and informed the treaties and the alliances that were struck. While the experiences of today's Anishinaabe are significant, the jurisprudence is clear that the common intention is what the perspectives and positions were in 1850. Indeed, says Restuel at paragraph 180. A time then, before the insidious assimilative actions of the Crowns had started to be imposed on the Anishinaabe principles and their governance and laws. At paragraphs 10 and 11 of their factum responding to the intervenors, Ontario states that they disagree that they have an obligation, and I quote, to consider all information shared with it at any time in the past. You'll find that at paragraph 11. We say that is wrong. Stage one was about identifying the common intention, and it sorrows me that the Crown would take such a dismissive approach, and one that we say is contrary to their obligation to act honorably and justly. Such an approach by the Crown shows that while they like to refer to Anishinaabe principle of responsibility, that they don't understand what it entails from an Anishinaabe perspective. At paragraph 171 of the Supreme Court of Canada's decision, you'll find that at page 10 and 11 of our compendium, the Supreme Court of Canada agreed with the Court of Appeal that the Anishinaabe, quote, would not have understood how a leader could choose to act, and in subquotes, arbitrarily without regard for the needs, requests, and expectations of others, and subquote, because this was not, and further subquote, not consistent with Anishinaabe conceptions of leadership or their expectations of the Crown, end quote. Dr. Boecker spoke about how the Anishinaabe understandings of leadership meant that they would have expected leaders to be responsible for people and for the leaders to provide for and to be generous towards those under their care. You find that at the Boecker Stage 1 report at paragraph 5.
By chance, are you referring to a compendium that you're filing?
We do not have that in our compendium, regrettably.
Are you filing a compendium? Okay.
Pardon me.
Coming up. Okay, thank you. Go ahead.
And this view of leadership and responsibility was agreed to by the Supreme Court of Canada at paragraph 179. In that same paragraph, the Supreme Court of Canada agreed with the Anishinaabe that the augmentation promise implicated future revenue sharing, as that too was consistent with the Anishinaabe principles and therefore part of the common intention and the shared goals, expectations, and understandings. In our submission, respectfully, Ontario was wrong. At paragraph 22 of their intervenor factum, that there is some sort of distinction between treaty interpretation and treaty implementation. Perhaps they are correct from a Eurocentric perspective. But again, the Supreme Court of Canada held at paragraph 180 that the shared goals, expectations, and understandings that Ontario claims to refer to implementation solely were to include the Anishinaabe principles. As such, the Crowns are wrong that they did not have an obligation to consider stage 1 evidence.
I have a question, Mr. Worm.
Yes.
Do you recall, or does anyone recall, whether at stage 3, the stage 1 evidence was what? Incorporated, relied on? What was the status? Does anyone recall? Or?
We weren't at stage 3, but as I understand it, the plan was that all of the stage 1 evidence was part of the record for stage 3. That was,
Part of the record?
that if
Okay.
someone who actually participated in stage 3 wants to correct me, that's fine.
I'll just, it could be an incorrect answer, whatever we're getting, but I'm just trying to refresh my memory about the relationship between the two bodies of evidence. Mr. Schachter?
Yes, Mr. Schachter here. Ms. Boise-Parker is correct. My recollection is that the stage 1 evidence was incorporated by reference into stage 3, and it forms part of the record of stage 3. And so the simple answer is, since everyone agrees that stage 3 is part of this process, so would stage 1 be.
Okay, I didn't need the argument. Thank you.
Thank you, Mr. Schachter.
And of course, I'll hear from the Crowns on that if you wish.
I can just say both Canada and Ontario agree that the stage 1 materials were incorporated by reference into the stage 3 materials and therefore part of the record.
Okay, thank you very much. Mr. Rankin?
Thank you, Your Honor. I agree with what Ms. Evans just indicated.
Very helpful. Thank you.
I thank my friends for that intervention. So as I was saying, it's our position that the Crowns were wrong, that they did not have an obligation to consider stage 1 evidence, as even by their own distinction, the Supreme Court of Canada's guidance is that the exercise of determining the sharing required by the augmentation promise still includes being led by Anishinaabe principles. And in fact, at paragraph 180 of the Restoule decision, the Supreme Court of Canada agreed that not only is the exercise to be led by Anishinaabe principles, but also by the Crown's commitment to be both liberal and just. I am concerned about how these Anishinaabe principles seem to have become rote words that can just be conflated with dictionary definitions. The content given to the principles in stage 1 evidence, it would seem, has been pushed to the background. These principles are not like bounded conceptions of language, but they are, as the Supreme Court of Canada acknowledged, relational. Each principle is linked to the others in sort of a web, in a mesh. For example, renewal is key to the principles, like the covenant chain: respect, responsibility, and reciprocity, and of course, renewal, are not one-offs, but require, in the language of the covenant chain, polishing to maintain the relationships and the alliances. The crowns don't get to fill the content of the Anishinaabe principles. And this is part of the reciprocity that is similar to what happened in 1850. Robinson sought a treaty under colonial laws, while the Anishinaabe infused it with and understood it from their own perspective. And as indicated, the diplomacy and protocols of the time, as manifested in the diplomatic metaphors that were adopted by Robinson and were reflected in his speeches. These principles are more than just relational. They are about a different way to understand. They are about a different way to view and to interact with the world and the human persons and non-human persons that dwell within. This was at least acknowledged by the Supreme Court of Canada in Restuel. For example, at paragraph 17, Supreme Court of Canada noted, and I quote, "Two key organizing principles of Anishinaabe law and governance are Pamatisuin, principle that everything is alive and sacred, and Gizewadzuin, the way of the Creator, which encompasses sacred laws and creation," end quote. The treaties themselves, as well as the shared goals, expectations, and understandings, are rooted in the Eurocentric common law, but owe their genesis to the trans-systemic approach. Pardon me. Understandings are not rooted in Eurocentric law, but owe their genesis to the trans-systemic system, and as such are expressions, for better or worse, of a trans-systemic legal agreement. We saw and heard during stage one about how Robinson did not just swoop in and impose his and his boss's colonial views. He instead participated in a trans-systemic or intersocietal council fire, adopting and performing Anishinaabe diplomacy, protocols, laws, and values. And since the earliest encounters with those from across the pond, starting with the Dutch, followed by the French, and then the English, as doctors Corbière and Boecker in their stage one evidence spoke to, those foreigners exercised the same trans-systemic protocols. Starting, as this honorable court has heard, with the covenant chain that was first a rope and then iron, and eventually grew to reflect the value of that relationship into a silver chain. The use of wampum diplomacy, as Dr. Alan Corbière spoke about during stage one, did not arise after foreigners arrived, but it was a long-standing practice, and that practice survives today. So the task facing this honorable court here is how to contribute to the trans-systemic legal agreement. And this is why the task facing this honorable court is a sui generis process. It involves a renewal of Robinson's participation in a trans-systemic process. Moving on to the second point briefly, with regards to the issue of Crown allocation. The Robinson Huron Anishinaabe are of the opinion that the successor to the British Crown includes both the federal Crown and the provincial Crown. From the Anishinaabe perspective, the principles of respect, responsibility, reciprocity, and renewal apply equally to whatever emanation of the Crown has received benefit, has received the bounty, and has the de facto responsibility to manage the resources and land that our ancestors agreed to share with the Crown in 1850. Both Canada and Ontario derive benefits directly and indirectly from treaty lands and resources, and share de facto responsibility and jurisdictional responsibilities respecting Robinson-Huron Treaty territory. Accordingly, the Robinson-Huron Treaty Anishinaabe view is that both Canada and Ontario are responsible for the implementation of the Robinson-Huron Treaty Augmentation Promise going forward. It should be remembered that the Crown allocation issue for past compensation is one that is largely between the Crowns alone. While the Robinson-Huron Treaty Anishinaabe have pled and argued joint and several liability, or Canada as paymaster in the alternative, the bulk of the issues related to Crown allocation arise from the Crown's cross-claim. Further, the Supreme Court of Canada has stated on numerous occasions that the constitutional purpose of Section 35 is reconciliation, as was affirmed in Restoule. It is also said that reconciliation involves reconciling the prior existence and sovereignty of the Robinson-Huron Treaty Anishinaabe with the de facto sovereignty of the Crown. It follows, therefore, in the interest of reconciliation, that because both Canada and Ontario exercise a measure of de facto sovereignty over Robinson-Huron Treaty lands and ought to be held responsible for the go-forward implementation of this treaty promise. Finally, Your Honor, I just want to end my comments with the statement a unanimous Supreme Court of Canada has held at paragraph 1 in Mikisew, which unfortunately is not included in our compendium, but the site for that
Find it.
is Mikisew Cree Nation versus Canada, Minister of Canadian Heritage, 205, Supreme Court of Canada at 69.
Thank you.
And I quote, "The fundamental objective of the modern law of Aboriginal and treaty rights is the reconciliation of Aboriginal peoples and non-Aboriginal peoples and their respective claims, interests, and ambitions. The management of these relationships takes place in the shadow of a long history of grievances and misunderstandings. The multitude of smaller grievances created by the indifference of some government officials to Aboriginal people's concerns and the lack of respect inherent in that indifference has been as destructive of the process of reconciliation as some of the larger and more explosive controversies. And so it is in this case." End quote. We say the Crown has an obligation to further the goal of reconciliation, and that goal can be hindered by explosive controversies or through death by 1,000 cuts. This litigation is historic, and it is not complete. The council fire can yet again be a site for the renewal of the trans-systemic legal relationship between the parties. And it is hoped that the resolution of this review will complement and advance that relationship for the betterment, not just in respect of the Robinson-Huron Treaty Anishinaabe or the Robinson Superior Anishinaabe, but for all Canadians. And subject to any questions that Your Honor might have, I would surrender the podium to my learned friend.
Thank you very much.
Thank you.
Good morning, Your Honor.
Thank you. Just give me one moment, please, to catch up. Whenever you're ready. Thank you.
For the record, my name is Catherine Boise-Parker. I am one of the lawyers representing the RHT and Anishinaabe who have intervened in this case. My friend drew your attention to the oral compendium that we've handed up. We should mark that as the next exhibit, if we could, please.
Would that be exhibit D then, I believe?
Yes, Your Honor.
Let me just.
So as you know, and we have discussed, the RHT and Anishinaabe have intervened in this review to make submissions on select matters to ensure they are not prejudiced in the go-forward implementation of the Robinson-Huron Treaty. In my submissions, I'm going to spend most of my time on three issues. One is the nature and limits of the Crown's discretion and the role of the courts in reviewing that discretion. The second is the Anishinaabe understanding of process. And the third is the importance of deep engagement with Anishinaabe principles in any decision made by the Crown. In our factum, we address two other issues, which I will just touch on briefly. One is the means of measuring the wealth of the territory, and one is what can't be learned from the RHT settlement. I think from the responses of the Crowns in their factums, we may not need to be concerned about those issues affecting anything going forward, so I won't spend as much time on those, but I will briefly touch on them. So I'd like to start with this question about the relationship between the Crown's exercise of discretion and the court's role in ensuring that treaty rights are respected and upheld. And I want to start by looking at what the Supreme Court of Canada did with respect to the treaty right, because of course they adopted a slightly different interpretation of the treaty right than what happened in stage one. So at page 1 of our condensed book, we have the Supreme Court of Canada's decision. And I want to start at paragraph 153, which is where they talk about the nature of a discretionary decision generally. And this discussion is taking place in terms of reviewing what they refer to as the first interpretation, that the Crown has an unfettered and unreviewable discretion, which you'll remember was both of the Crown's positions when we started stage one, and one that Ontario hung on to for quite a while, including when it got to the Supreme Court of Canada. It admitted that there was some procedural obligations, but still no substantive obligation, that its discretion was unfettered in that regard. And the Supreme Court of Canada rejects that, says it's easy to reject that because it doesn't fit within Canadian notions of legality and can't reflect the common intention of the parties. At paragraph 153, they say discretion refers to those decisions where the law does not dictate a specific outcome or where the decision maker is given a choice of options within the constraints imposed by law. So of course, that's the part that we're concerned about, within the constraints imposed by law. The legal constraints can include, but are not limited to, statute, the principles of the rule of law, the principles of administrative law, the fundamental values of Canadian society, and the principles of the Charter. In the present context, the relevant legal constraints include the constitutional principle of the honor of the Crown. At paragraph 154, about 5 lines down, they quote from the City of Montreal case, "In a country founded on the rule of law and in a society governed by the principles of legality, discretion cannot be equated with arbitrariness." And then they go on to say, "Our law requires discretion to be exercised within a specific legal framework and recognizes that discretionary acts fall within a normative hierarchy." So the question for the court is, what is the specific legal framework within which the discretion must be exercised? The next excerpt in that tab of our condensed book is paragraph 169, which talks a bit about how the Anishinaabe would have understood discretion. And paragraph 169, about 5 lines in, the Anishinaabe would have understood that Her Majesty would be generous and would decide according to the principles of respect, love, and honesty. And later on in the quote from Elder Corbier, "And the way the Anishinaabe lived with the 7 teachings, to be generous, to be kind, to be truthful, and all those good teachings, good heart teachings that were given to us, if they lived those, then they would also expect the leader, expect the queen to be living the same way." And then in the next paragraph, she would show love according to the principles listed there. Paragraph 173, second sentence, "The Anishinaabe understood the Crown would be generous in exercising the discretion referred to in the Robinson Treaties and would take the Anishinaabe's needs and circumstances into account, as well as the needs and circumstances of non-signatories." And then at paragraph 195, now the court has gone through the various interpretations of the treaty right. And remember, that's what it's doing here. It's talking about what the treaty right consists of. And it sets out its conclusions. Starting with the second sentence, "A fixed annuity with discretion for the Crown to increase the annuity beyond a soft cap if economic conditions improved, allowed the Crown to secure the ceded lands for settlement and mineral development at a time when the province lacked resources. At the same time, the Anishinaabe were prepared to trust the Crown to act liberally and justly with all Her Majesty's subjects, including the Anishinaabe, and to increase the annuity when circumstances warranted." That was the trust. This was entirely consistent with the Anishinaabes' conception of a good leader and reflected the principles of respect, responsibility, reciprocity, and renewal. The Robinson Treaties recognized the Anishinaabe's authority to conclude agreements to share their territory and the responsibility to their people, embodied the idea of reciprocity and mutual dependence, and cemented a long-standing nation-nation relationship that would be renewed in perpetuity. And then, starting at paragraph 196, they set out their conclusion about what that right consists of. They talk about the Crown being obliged to go up to $4, as was done in 1875. And then about 7 lines down in paragraph 196, "If the economic conditions are such that the Crown can increase the annuity beyond $4 a person without incurring loss, the Crown must exercise discretion and determine whether to increase the annuities, and if so, by how much." This exercise of discretion is not unfettered. It is justiciable and reviewable by the courts. And now they're going to tell us on what basis it's reviewable. Paragraph 197, the Crown must exercise its discretion, including its discretion as to how often it turns its mind to increasing the annuity, diligently, honorably, liberally, and justly, while engaging in an ongoing relationship with the Anishinaabe based on the values of respect, responsibility, reciprocity, and renewal. That's the legal framework that bounds the Crown's discretion. It goes on to talk about the 5 factors that will be relevant to assessing that, non-exhaustive factors. And at the towards the end there, it says, including its duty to diligently implement its sacred promise to share in the wealth of the land if it proved profitable. That's at the end of paragraph 197. So that's the sacred promise, is to share in the wealth of the land. Promise is to exercise discretion about that. That's the promise, is to share in the wealth of the land, and then the Crown is obliged to exercise its discretion with respect to that when there is wealth, and it is obliged to exercise its discretion in accordance with those principles. Previously,
Go ahead.
Previously, at paragraph 18 of the decision, the court had set out its understanding of those Anishinaabe treaty principles. The Anishinaabe system of governance and the relationship with the Crown have always been based on the values of respect, responsibility, reciprocity, and renewal. The Anishinaabe sought respect for their jurisdiction and their authority to conclude agreements to share their territory. This is They don't give the trial judge credit, but it pretty much comes from a stage 1 decision. They acted with a sense of responsibility to ensure their people could continue to depend on the land for sustenance, shelter, medicines, and spiritual well-being. Reciprocity, essential to the formation of alliances, meant that a gift would attract a reciprocal gift of commensurate value based on the idea of mutual interdependence. This value reflected the notion that people must rely on one another to survive, not simply as economic necessity, but also as a moral imperative. And renewal invoked the idea that relationships, such as the treaty relationship with the Crown, are ongoing and must be renewed continually. This is part of the legal framework that bounds the Crown's discretion. So we say the Supreme Court of Canada's decision makes clear that the Crown's discretion must be exercised within constraints imposed by the requirement to do so in a diligent manner that furthers the purpose of the treaty generally, and the annuity promise specifically, the requirement to be liberal, honorable, and just, and the requirement that its actions be consistent with an ongoing relationship with the Anishinaabe based on the Anishinaabe Treaty principles. So we say the Anishinaabe have a constitutionally protected treaty right to have any discretionary Crown decisions about the annuity made in accordance with that standard. We discussed this starting at paragraph 27 in our factum, that this is the legal framework that constrains the Crown's discretion. Although it contains more detailed requirements than just whether the decision is honorable, we could, and if it's okay with the court, I will refer to these sort of interconnected requirements as the standard of an honorable treaty partner. That is the standard the Crown must meet in making its decisions when it exercises its discretion. And we say this is, without a doubt, a sui generis legal framework. But it's informed by other legal frameworks that govern the exercise of discretion. So, for example, there was a discussion the other day about prejudgment. So whenever a decision maker makes decisions through the exercise of discretion, they can't prejudge the issue. They can't make the decision on the basis of irrelevant factors. Of course, that would all be folded in to the standard of an honorable treaty partner. Similarly, the fact that a decision has to be transparent so that people understand the basis on which it was made, that, of course, would be part of the standard of a reasonable treaty partner. So the treaty doesn't expressly dictate a specific amount or percentage or share of revenues, but we say it guarantees or promises an honorable process and an honorable outcome. And what's honorable is to have any exercise of Crown discretion be consistent with the identified requirements with the standard of an honorable treaty partner. Now, I'll get to later the fact that, if everything's working in a healthy way, a healthy treaty relationship, we're not going to have unilateral exercises of discretion very much. We're going to have agreements. But if the Crown imposes a result through the exercise of discretion on the Anishinaabe, then the court has got to review it to ensure that it meets the standard of being honorable. Now, there may be a number of outcomes or processes that meet this threshold of constitutional compliance. And in their factums, the Crowns try to argue that because there could be more than one answer that meets the standard, then what the court is doing is applying a standard of reasonableness to the Crown's decision, and therefore there has to be deference to the Crown. That's, as I understand their argument. But we say, and we talk about this in our reply factum starting at paragraph 10, this argument is based on what we say is a false binary, that there are only two choices for this court: a correctness review, which is premised on one possible outcome, or a deferential reasonableness review. And we say, obviously, because it's sui generis, it doesn't have to be either one of those things. But even in the administrative law context, which we'll go on to explain why we're not there, but even in the administrative law context, that's not the only way to think about what the court does when it reviews a decision. And we refer in our reply factum at paragraph 8 to 10 to the standard applied when a court is reviewing a decision for procedural fairness. Now, we're not saying that the standard of an honorable treaty partner is a procedural standard. It is clearly more than that. It applies to both the substance and the process that the Crown adopts. But it is, Ontario says administrative law principles are instructive. We agree. It's instructive to note that when the court is reviewing a decision for procedural fairness, there may be more than one procedurally fair process. But the court doesn't show any deference to the decision maker's choice about what is fair. The question isn't, they sometimes say that when you're reviewing something for procedural fairness, there isn't a standard of review of reasonableness or correctness. You just say, is it fair? It, in some ways, amounts to correctness because there's no deference shown to what the decision maker has done. But that doesn't mean there's only one possible answer to it. And similarly here, we say in a review of the Crown's conduct, the question is just, was the Crown's conduct honorable? Was it consistent with the standard of an honorable treaty partner? by honorable, I'm taking into account that list of things that we've shown constrains the Crown's discretion. And we say that in answering that question of is it honorable, the court can't show any deference to the Crown's determination about whether the standard has been met. The content of that standard in any particular case is a matter of constitutional law. It defines the contours of what the Anishinaabe were promised about how the parties would engage in the relationship. It defines the range of constitutional behavior. And it is the duty of the courts, we say, to hold the Crown to this standard. There may be numerous processes and numerous outcomes that meet this constitutional threshold. And if those various results, all of which are honorable, involve the balancing of polycentric considerations, then it may be appropriate for the court to defer to a particular choice made by the Crown. But even in that,
Let me just get that proposition, please. You say if there is more than one correct answer,
honorable answer.
honorable answer. If there is more than one honorable answer, then it may be appropriate for the Crowns to balance polycentric considerations. And in that case, that Crown decision attracts some deference. Do I have those?
Well, I think
Concepts in order?
the Crown, even when the Crown is balancing polycentric considerations, there's going to be a range of reasonable outcomes. As long as whatever they choose falls within that range, it doesn't matter if the court can think of one that they think might be more honorable. This is the correctness standard, right? When you're applying the correctness standard, you say, what do I think is the right answer as the court? And then you say, did they meet that? That's not necessarily what you're doing here. What you're doing here is they come to you, they demonstrate that what they did was reasonable. As long as you agree it was reasonable, it doesn't have to be exactly what you would have done when it comes to the balancing of polycentric considerations, right? But it has to meet that. You have to apply a correctness standard or a what is honorable standard to whether it meets that threshold. And this is, we say this is, even when you're doing that though, even when you're applying some deference to their polycentric considerations, because they've demonstrated to you that it's overall honorable. Even when you're doing that, they still have to explain themselves. They still have those requirements of transparency. So once they show you what's honorable, then there may be some deference to particular choices they make within there. So in this case, I'm going to pick a random example.
I'm just going to stop you there.
Okay.
You say once the Crown has shown their decision is honorable, is another way of saying that once the court has found that the decision is honorable, then there may be some deference. Or that, do you say once the Crown has shown that a range? But in fact, every time I hear the word range, if we're talking about quantum, as opposed to process, whenever I hear range, I am presuming actually you're speaking less about range than about methodology or approach.
Well, I would think that some of the matters that are at issue here in this particular review, things like the bring forward rate.
Mm-hmm. The big three.
Right. So the bring forward rate, I mean, we haven't made submissions on this, but that seems like it's actually a question of principle. It's actually not about balancing polycentric considerations. That would come after you applied the correct principle about what the bring forward rate should be, right? So you would have to, that decision about whether they picked the bring forward rate, you have to see whether that was honorable. Whether and they would have to persuade you that it was consistent with the Anishinaabe principles and the requirement to be just and honorable and fair and liberal and generous. But let's not overdo the deference, because the Supreme Court of Canada didn't say really too much about deference here. They said some measure of deference, and their measure of deference was, we'll go through Vavilov and we'll talk about why deference is the presumption when it comes to administrative law, why it's not the presumption here. But the deference that the Crown, the deference that the Supreme Court of Canada was referring to is the reason we think they were talking about being deferential is because they talk about the relative expertise of the courts versus the Crown in balancing these considerations. So the only time you get to even thinking about what the level of deference is when you're talking about that part of the exercise.
The exercise of expertise.
The exercise of balancing polycentric considerations, right? If you buy that the Crown has better expertise on that, which the Supreme Court of Canada tended to suggest, then the deference is only relevant there. It's not relevant to what is the proper pot to be shared. That's a matter of interpreting treaty, the intentions of the parties, what's consistent with the Anishinaabe principles. That's not balancing considerations. How many Anishinaabe there are, you don't have to be deferential on that. That's not about their expertise, right? I mean, kind of what the Crowns have done is they've tried to wrap the entire decision in this polycentric mantle and say, well, the whole thing is polycentric. They can't do that. They can't do that because that and then ask for some deference with respect to their balancing of those considerations, because that insulates the decision from review. And that's one of the things that distinguishes the RHT settlement in a global basis from what the Crown has done here. When the Crown is going to make a unilateral decision, it's got to explain how it has done that. It has to tell you what the factors were that went into that, and then you review all of those factors on a correctness standard or on an honorable treaty standard, which will amount to correctness when it comes to consistency with these principles. Now, you'll remember that within the Anishinaabe principles is respect for both treaty partners' autonomy. So a certain measure of respect for how the treaty partner has to deal with its extra obligations, its other obligations, is baked in to the way the parties decided to treat each other. So there's, as long as they're being honorable towards the Anishinaabe, they have some room to maneuver with respect to how they balance their various competing considerations. But they have to demonstrate first that the principles on which they proceeded were honorable and consistent with the Anishinaabe treaty principles. And that's why we say that this approach is consistent with both legal orders. The Canadian view is that constitutional issues have to be decided on a correctness basis. And they have to be right about that. The Crown has to be right that it's acted consistent with the principles that it promised the Anishinaabe were going to govern their relationship. And this is appropriate because for the Anishinaabe, those fundamental principles that govern the treaty relationship are also the ones that govern the Anishinaabe and their relationship with the land and what made them able to enter into the treaty with the Crown. So in that sense, those fundamental principles are binding on both parties. But as I've said, one of those principles is some respect for internal autonomy.
And how is that respect for internal autonomy brought into this exercise?
I think that's why, as long as the Crown can demonstrate that they have acted consistent with principles like reciprocity and renewal and respect, then the Anishinaabe and the court are going to show are going to show respect for the Crown's internal processes for balancing competing considerations. But they have to meet that constitutional threshold first. So when my friends talk about a range of outcomes, and we don't make submissions on this, but just sort of as an example, the question of whether or not you're going to look at one revenue stream or the entirety of the financial benefits that flow from the treaty territory, that seems to me like a question that goes to the honor of the Crown. That goes to the fundamental treaty principles. You can't, it would be very unfair and contrary to the principles of respect and reciprocity if the Crown took.
You're talking about the debate between rents and.
Yes, yes. So if they said the only thing that's relevant is what we decided to collect unilaterally through one revenue stream, meaning NCRRs, and we collected a whole bunch through another revenue stream, but that's not included. That seems like a principle that raises these fundamental, it's inconsistent with these fundamental treaty principles. But if the Crown says, well, we acknowledge that we have to look at the entirety of our financial benefits, but our way of estimating them, there's 4 different ways to estimate them, and this is the way that we estimate them, and they're all relatively reasonable ways of estimating them, then defer to the Crown doesn't have to prove that. So there's something where, you know, they pass the threshold of constitutionality, but there's still a range of outcomes. But that fundamental decision about what they're going to count in terms of, are they just going to count the one thing that happened to fall into one revenue stream rather than the totality of their benefits, that raises an issue of principle that has to be decided in accordance with the principles that the parties agreed would govern their relationship. So we say that the standard review is sui generis, and it's one that will be developed over time. And it's very different than a statutory decision maker, and this exercise that you're engaged in is very different than judicial review. Of course, judicial review sometimes just means you review the Crown's activities. I mean,
Review by.
a review by the court of the Crown, right? I mean, the charter said now more Crown actions is going to be subject to judicial review, meaning in a breach of charter claim. But I think when we say judicial review, we all have a certain way of understanding what a statutory judicial review is, which gathers with it things like deference. And in our view is very inconsistent with sort of the nation to nation relationship about what's happening here. The Crown is acting in a very different capacity than as a statutory decision maker. And the rationale that leads to a deferential review with respect to an administrative law decision just doesn't apply here. And we spend a little bit of time on Vavilov, which is at tab 3 of our book, and I'll just take you there quickly.
In your,
In the condensed book, tab 3.
thank you. Go ahead.
At paragraph 23, you'll see the first sentence, where the court reviews the merits of an administrative decision. The standard of review it applies, except with respect to natural justice, the standard review it applies must reflect the legislature's intent with respect to the role of the reviewing court, except where giving effect to that intent is precluded by the rule of law. So it's about respecting legislative intent. Similarly, at paragraph 24, where a legislature has created administrative, second sentence, where the legislature has created an administrative decision maker for the specific purpose of administering a statutory scheme. Sorry about that. We've all read this so many times, sorry. But the legislature intended the decision maker to be able to fulfill its mandate and interpret the law as applicable to all issues that come before it. So it's about the legislature gave this decision to the decision maker is the one that should make the decision. Paragraph 30. This is where they say we're no longer going to go through the analysis, the contextual analysis that used to determine the standard of review. We're not going to talk about expertise and so forth. And in the second sentence, instead, in our view, it is the very fact that the legislature has chosen to delegate authority which justifies a default position of reasonableness. Again, at 32, they refer to the respect for legislative intent. In paragraph 33, they refer to legislative intent as the polar star of judicial review. Now, of course, here, we're not concerned with legislative intent. We're concerned with the intent of the parties. And this gives rise to at least two matters. One is this question of the standard of review. There would be no doubt that the Anishinaabe did not expect the Crown's view of what is honorable to be privileged in this treaty relationship.
Say that again.
That the Anishinaabe would have expected their view and the Crown's view to be equally considered in the definition of what is honorable. If you defer, if you apply a reasonableness standard and defer to the Crown's view of what is honorable, you're privileging the Crown's view of what is honorable. Instead, it is the court, not the Crown, who decides what is honorable. I'm sorry, I left Vavilov just a minute too soon. Because I just wanted to make the point starting at paragraph 55. Questions regarding the division of powers between Parliament and the provinces, the relationship between the legislature and the other branches of the state, the scope of Aboriginal and treaty rights under Section 35 of 1982 Constitution Act 1982, and other constitutional matters require a final and determinate answer from the courts. Therefore, the standard of correctness must continue to be applied in reviewing such questions. Paragraph 56, the Constitution, both written and unwritten, dictates the limits of all state action. And then the last sentence of paragraph 56, the constitutional authority to act must have determinate, defined, and consistent limits, which necessitates the application of the correctness standard. So because the source of the discretion is a treaty entered into by in a relationship of equality, an alliance between equals, there can't be any privileging of the Crown's position. Because it is a matter of constitutional law, because it defines the boundaries of the Crown's authority, there can't be any deference shown to its determination. Now, as my friend Mr. Bass pointed out, the Crown seems to concede that the scope of treaty rights must be subject to a correctness analysis, whether we're in Vavilov or some other sui generis standard. But they try to distinguish this question of interpretation of scope from the honorable implementation of the rights. And we talk about this starting at paragraph 18 of our reply factum. And we say that's an artificial distinction. So when the court's deciding whether the Crown actions have met the standard of an honorable treaty partner, the court is defining the scope of the Crown's obligation. That's the standard. If I say reasonable, I mean honorable, an honorable treaty partner. Sometimes that includes the requirement to be reasonable. So defining the scope of the Crown's obligation is just the flip side of the scope of the treaty right. Wouldn't make any sense to define the treaty right carefully and then not be careful about what constitutes a breach. The Fort Mackay case is at tab 4 of our compendium. We don't have to go there, but there's a case where it was an appeal, I think, of the decision of the AER in Alberta, and you could only have this appeal if it was a question of law, and the standard that they applied was correctness. But the question was Treaty 8 being honorably implemented? There's no reason why honorable implementation or the diligent implementation of a treaty would be separate from the interpretation of the treaty. In fact, the duty of diligent implementation starts with the obligation to interpret the treaty in a generous manner. So whenever the court is considering how a treaty has been implemented in a particular case, it involves issues of treaty interpretation. It involves consideration of common intention. And the Crowns, at least Ontario, seem to say, well, these questions of common intention have all been settled. That's not the case. The Crown suggests that, look, we've done all the interpretation we need to do in this case. Now it's just a matter of the Crown going off and exercising its discretion to implement the treaty. And again, as Mr. Bass pointed out, what the Supreme Court of Canada was doing was reviewing the stage 1 and 2 decisions. That was a very specific question of interpretation. It was about whether the treaty obligation was limited to $4. There were a few other interpretive issues that the court was able to address, but it wasn't didn't purport to address every interpretive issue regarding the treaty right. And the Court of Appeal understood there was a whole host of outstanding interpretive issues. But more troubling, when the Crown says this, when they say, well, interpretation's done, now it's just implementation, they are again backsliding into a transactional approach to the treaty, as if everything is settled by an interpretation of something that happened in 1850, and now they're going to go off on their own. But as every court has said, it's not a one-time transaction. It's an ongoing relationship. The obligations are at their core relational, and they have to be applied to every aspect of the treaties, of the parties' relationship as it develops into the future. And the court's role is to supervise that, make sure that that's happening. The application of the parties, what the parties' understandings were in 1850 to the modern context is a pretty complex task, but it's not one that the Crown can conduct on its own. It has to be guided by the expectations and understandings of the parties in 1850, which is their common intention. And it has to be done together with the Anishinaabe. Now, it is to be hoped that at some point, the court doesn't have to participate so much in supervising the treaty relationship. But we have, as I'll go on to explain, a big deficit here of trust and a big deficit in the Crown's understanding of what its treaty obligations are. And until we've rebuilt that trust and the Crown has demonstrated that it understands its treaty obligations, the Anishinaabe, who have become a very vulnerable partner in this treaty relationship, need to be able to come to the court for assistance in ensuring that the Crown meets its obligations. Before I leave this question of the relationship between the Crown discretion and the role of courts, I want to talk about the duty to consult cases, because my friends say, well, parts of the duty to consult analysis are done on a reasonable basis, and that's a constitutional question. So this should be done on a reasonableness basis as well. And as Mr. Bass pointed out in his submissions, the duty to consult is very different for a variety of reasons, and we talk about that at paragraph 25 of our reply factum. These include that it arises sometimes with respect to unproven rights, and it's primarily a procedural duty. But it's more than that. I guess I'll also say that, as he said, parts of the analysis are done on a correctness standard, and after Vavilov, I think it's uncertain whether the law which says that the review of the sufficiency of consultation is done on a reasonable standard. We're not really sure if that survived Vavilov. At tab 14 of our compendium, do you have a tab 14?
I do. It's a duty of consult article.
Right. Oh, there's mine. Thank you.
That's what you're hoping for?
Yes, thank you. We cite this in our reply factum at footnote 38, where you can hyperlink to the entire article, but we just have excerpted it here.
And where is it in your reply factum?
It
Oh,
is
you see.
footnote 38.
Okay.
In the interest of time and the sanity of the court reporter, I'll try to avoid reading this entire passage to you, but I commend this article to you because it is very, very helpful. It starts out at page 56, talking about the fact that there has never been any question that with respect to separation of powers and division of powers questions, the standard is correctness. And that's because it, as they say, and about halfway down there, they quote the Supreme Court of Canada, "It is the high duty of this court to ensure the legislatures do not transgress the limits of their constitutional mandate and engage in illegal exercise of power." And they go on to say that questions about the scope of aboriginal rights, and of course, this would include treaty rights, and we would say even more so with respect to treaty rights, ought to be understood as stemming from the same concerns that arise from the division of sovereignty among the legislatures and among the branches of government. So while Section 35 is framed in the language of rights, it's really, as we know, about reconciling sovereignty and defining what is constitutional jurisdiction. So, and the third paragraph on that page says, what Section 35 protects then are not a range of discrete liberal rights analogous to those under the Charter, but held by a distinct minority. Rather, the rights that Section 35 recognizes and affirms reflect pre-existing Indigenous sovereignty and law. They are shaped by the body of intersocietal law, both customary and positive in form, that developed through the interaction of these pre-existing legal systems with incoming European legal systems. Last sentence, as such, they act on a limit of crown sovereignty. And this is, he talks about Indigenous legal orders survive the assertion and acquisition of crown sovereignty and act as a limit on the exercise of crown jurisdiction. And this is so clearly true in this particular case, where the Crown has accepted a constitutional obligation, has made a promise which incorporates the Anishinaabe Treaty principles. Now, I think that my friends from the Crown would agree that this article traces the development of the standard review with respect to the duty to consult, and says that, after Haida Nation, there was some uncertainty about the standard. And then in the Beckman case, Justice Binney's decision, which is quoted at paragraph 59, page 59 of this article, seemed to suggest that the process undertaken to discharge the duty would also be subject to review on the basis of correctness. So you'll see, in exercising his discretion under the Yukon Lands Act and the Territorial Lands Act, the director was required to respect
Are we
legal.
still on page 56?
Sorry, no, page 59.
Got it.
So Justice Binney says, in exercising his discretion under those statutes, the director was required to respect legal and constitutional limits. In establishing those limits, no deference is owed to the director. The standard of review in that respect, including the adequacy of consultation, is correctness. A decision maker who proceeds on the basis of inadequate consultation errs in law within the limits established by law and the Constitution. However, the director's decision should be reviewed on a standard of reasonableness. And the authors go on to say, in other words, the adequacy of consultation establishes a threshold for assessing the constitutionality of the Crown's conduct. Once it is determined that the Crown acted within constitutional bounds, subsequent decisions would be reviewed on a reasonableness standard. Now, the Crowns will tell you that that didn't survive. And that the adequacy of consultation is often now treated as a matter that is reviewable on the standard of reasonableness. And I think they rely on the Tanaka case. And that case involved the approval of a ski resort by the Minister of Forest, Lands and Natural Resources. It was a statutory decision. It was made under the Land Act and the Ministry of Lands, Park and Housing Act. It involved the minister reviewing a very lengthy consultation process, which the minister found was sufficient to discharge the duty to consult.
The reporter noted that they're relying on Taku-Hicken case. Is that what you meant to say?
No. No, it's a different case. It's this case that my friend has brought up. It is not in our compendium, I'm afraid.
Thank you.
Do you want me to spell that or you got it there? Thank you. So, do you have the paragraph there? I don't remember. You just search for adequacy. I've lost my paragraph number here. Or search for reasonableness. In this case, what the court says is that the determination of the sufficiency of the consultation is just one of the factors that goes into whether the decision was reasonable. No. Sorry, I'll get that for you after the break. But I can go ahead and make the point I wanted to make. In that case, as in most duty to consult cases, what the statutory decision maker is doing is engaging in statutory power of decision, which we know under Vavilov attracts a deferential standard for the most part. It is not engaging primarily in a constitutionally protected, in a constitutional question. It is a statutory duty. There are constitutional implications and a constitutional duty that arises with respect to the duty to consult. But it's administering a legislative scheme or a government or crown policy. It is not primarily addressing a constitutional issue.
Would this be a good time to break?
I'll just make one more point. In this case, the constitutional question is the main event. The Crown is not implementing a statutory decision or a Crown policy. It's actually performing its decision as its obligation as a treaty partner, discharging its sacred duty. So if the Crown is mistaken in what it's doing here, it has breached the treaty. It has effectively deprived the Anishinaabe of their constitutionally protected right. So it's a very, very different context than what we see in that case and in the duty to consult cases generally. And just as a final matter, it is uncertain whether that holding in Tanaka will survive Vavilov's statement that constitutional issues generally are reviewable on a standard of correctness. So thank you for indulging me for the last few minutes.
Thank you. We'll take a break now, 15 minutes.
Thank you.
This court is adjourned for 15 minutes.
All right.
This court is resumed. Please be seated.
Are you good for time, Ms. Boyce-Parker?
Yes, I'm not sure that I'll be done at 12:30, but we might decide to just stay until 1 rather than break and come back. We can talk about it then if you like.
When you say stay until 1 and then because you would be finished?
Yes, if at 12:30 it looks like I'll be finished by 1, we might just want to continue rather than break for lunch, if that's okay with you.
Let's keep an open mind to
See
that.
what we- Always having in mind my tendency to fly through. Mr. Albanati has brought up the paragraph I was referring to from Kanaka. And you'll see there that what they did was they treated the determination about sufficiency of consultation just part of the review of the minister's, the reasonableness of the minister's decision. That's very different than what's happening here, where the constitutional issue is front and center. The Crown is actually engaged in discharging its constitutional obligation, acting within the constitutionally protected treaty relationship. I'm going to move on now.
Try
To us.
that again.
I think it's both of us. Oh, there we go. I'm going to move on now to my second point, which is the importance of process. But to start that, I'm actually going to address a second thing that I say, a second implication that arises from the fact that the treaty and not the statute is the source of the discretion. And this has to do with the position that Ontario took during the negotiation, and that I think it argues in its factum that it couldn't fetter its discretion by coming to an agreement with the Anishinaabe about how the discretion would be exercised. Because this is related to this topic of process. And we say that Ontario's position demonstrates how fundamentally the Crown, or at least the Ontario Crown, has kind of misapprehended its obligations and the nature of the treaty relationship. So again, looking to the source of the discretion, this is not a case where the statute has directed that a specific decision maker will make a decision through an exercise of discretion. And again, in order to respect legislative intent, in those kinds of circumstances, you have to make sure that it's that decision maker who exercises their discretion to make the decision. That's what the statute intended. And so in an administrative law context, a decision maker can't fetter its discretion, because that would be contrary to the statutory intent that that decision maker exercise discretion to make the decision. But of course, the statute, the legislature, can constrain that discretion. That's often done. So in this case, there's no doubt that the Anishinaabe understood that the discretion would be exercised by the Crown in accordance with the relevant principles. And we heard a lot of evidence from stage 1 about how the Anishinaabe would have expected the Queen to exercise any discretion. Right? If there was a discretion to be exercised, the Anishinaabe expected it to be exercised by the Queen, who would act as a good, generous Ogima. And so, as the court discussed with Mr. Gover the other day, it very well may be improper for the Crown, one party to the treaty, to decide to fetter that discretion by having it be constrained by being consistent with some irrelevant consideration like the RHT settlement. So you talked about whether that could be a fettering of discretion if the Crown walked into the engagement session, deciding it wouldn't do anything except what was consistent with that. And that could be an improper fettering of that discretion. It might also be making the decision on improper considerations or irrelevant considerations. But there's nothing in the treaty relationship or the constitutional framework that would prohibit the two parties themselves from coming to an agreement about how the annuity should be increased or how the Crown's discretion should be exercised. Just as the legislature can limit a discretion that it grants, so too the parties could agree how the discretion would be exercised. And in fact, we would say, far from prohibiting an agreement between the parties, the Anishinaabe principles and the honor of the Crown strongly support, if not require, the parties to meaningfully engage in an effort to agree on protocols and processes for building consensus, at least some or all of the issues, and structuring the anticipated exercise of discretion through the development of negotiated approaches. So we discussed the importance of process. So that's just one point we want to make about process. There's nothing wrong with the parties coming to an agreement about how the determination is going to be made. There's no problem if the parties both agree. There's no problem with fettering discretion. Now, more generally, talking about
I'll ask this question of the Crown, but could it have been understood by the Anishinaabe treaty partners that when the Crown said we can't fetter our discretion by agreeing to certain of these propositions for the purposes of the discussions, that they were saying we don't have authority?
well,
Like, was that we can't fetter we can't enter into this deal because we're not the decision makers, we're agents at the table.
and that comes to my broader submissions on process.
And before, as you get there, know that one of my questions is, in the modern day of negotiations, whatever negotiations, labor negotiations, treaty negotiations, would one generally expect the ultimate decision maker to be at the table? For sure in early days or at all times?
I'm not sure it's a matter of who's at the table, although it is important who's at the table. There have to be people who have the requisite authority to engage in what's being done, which, as I'll explain, should be engaging in a discussion, a negotiation, a give and take, an attempt to build consensus. If they don't have authority to attempt to build a consensus, then there's no point in them coming to the meeting, because that's what they're supposed to be doing. And if it takes the minister to attend the meeting in order for the Crown to be able to engage in actual negotiations, the give and take of negotiations that will lead to building consensus, then the minister has to attend. But the Crown can organize itself differently than that. Because what they're trying to get to is an agreement so that they say, we've agreed that this is how the discretion should be exercised. You can't do that if all you're doing is listening. The importance of process and the consensual and deliberative process for the Anishinaabe is what I'm actually going to make my submissions on right now. So tab 10 of our condensed book contains an excerpt from the book by Dr. Boaker, which is the first resource cited by the Supreme Court of Canada in the Restule decision at their paragraph 4. And Dr. Boecker quotes at the beginning of chapter 4, among the Indians there have been,
Is this in your materials?
sorry, yeah, tab 10 of our condensed book.
Thank you. Page. Go ahead. What page?
The first page there,
Thank you.
the opening of chapter 4, governance and action. And she has a quote from George Copway that says, among the Indians, there have been no written laws. Customs handed down from generation to generation have been the only law to guide them. They would not be as brutes whipped into duty. They would be as men persuaded to the right. Anishinaabe consensus building protocols are about persuasion, about discussion. She goes on to say, to clarify, when she says customs, he noted, were the only law to guide them. For a Western audience, no written law has too often been read as no law. But of course, we know that's not the case. And she says, Copway went on to discuss in his chapter on traditional government, regular meetings of Anishinaabe councils ensured that customary laws were both enacted and followed after fulsome discussion within the community. Now, what this passage tells us is that deliberative processes are not just a procedural right, and they're not just discussions. They are part of how the intersocietal law that governs treaty making is developed. Regular meetings with the Crown are an opportunity for that development. To do what Mr. Schachter referred to as putting the meat on the bones of the basic principles that will guide the parties' relationship. The principles that the Supreme Court of Canada said in paragraph 303 should be the object of permanent negotiations to work out the details of the promises of mutual trust and assistance. The Anishinaabe would have expected that regular meetings with the Crown would have continued after the treaty. And more than that, they would have expected that the meetings would be attended by Crown representatives who understood and were familiar not only with Anishinaabe law and perspectives, but with the shared practices, principles, and protocols that had long governed the treaty relationship. And we saw in stage 1 the historical context of the treaty being filled with many examples of interpreters and cultural brokers and translators and other people who had been essential to this cross-cultural merging of perspectives and legal orders that enabled the Covenant Chain Alliance to develop as it did. People like Thomas Anderson, who was the superintendent for over 40 years, no, doing something else. And of course, Commissioner Robinson was said to be fluent in Anishinaabe and had decades of experience interacting with Anishinaabe through his role in the fur trade. These people did not have to be educated about Anishinaabe laws and the principles of the treaty relationship every single time. And the Anishinaabe would have expected that the Crown's institutional or corporate memory of the Covenant Chain Alliance would continue to be maintained. So the Anishinaabe in 1850 would have understood that there would be regular meetings involving negotiations aimed at resolving differences between the treaty partners through consensus-based deliberations. And this is because engaging in structured deliberative processes is a critical part, if not the most fundamental aspect of being an honorable treaty partner. And if we could just go to tab, I think it's tab 11. of our condensed book is an article by Mark Walters. And Professor Walters starts with the same quote from George Copway. But then page 188 of the article, 124 of the condensed book, about halfway down, he's been talking about the relationship between a right and a remedy in the common law.
Sorry, what page, please?
It's page 188 of the article or page 124 of the condensed book.
Thank you.
He says the close relationship between the substance of the right and the procedures associated with remedy is not unique to the common law tradition. Indeed, it seems also to have been a feature of the indigenous legal tradition, at least among the Anishinaabe people of the Great Lakes region of North America. That people were to be persuaded to the right, as Anishinaabe writer George Copway put it, reflected an understanding that what was right in any given situation could only really be appreciated through a particular procedure or form of discourse aimed at persuasion and agreement. And in this respect, not any kind of persuasion would do. As another 19th century Anishinaabe writer, William Warren, observed, it was at the council fire, the symbol of their nationality, that chiefs of clans and extended family lineages among the peoples of the Great Lakes met to resolve their problems through carefully structured forms of discourse. The remedy for a wrong was, from this perspective, to talk according to the procedural customs of the council fire with a view to sustaining or to securing a substantive right. So I think it's important to remember that the engagement process itself is part of maintaining a relationship consistent with the treaty principles. It is a critical part of being an honorable treaty partner. And what those discussions are supposed to be aimed at is resolving differences and building consensus. If we can just go back to Dr. Boaker's book at tab 10. You'll see on page 136 of the article, 117 of the condensed book. Second paragraph begins, as earlier chapters have demonstrated, Anishinaabe consensus-based governance practices through alliance and councils are old.
I need to catch up when you change places. So we're back
Sorry.
to Dr. Bohacker.
Dr. Boaker at tab 10.
Thank you. Page, please.
The second page of the article there, it's 136 on the article and 117. Oh, yes, 117. And you'll see towards the bottom of the first paragraph, she says, Anishinaabe councils were sites where Anishinaabe law was put into action. And the beginning of the next paragraph, Anishinaabe consensus-based governance practices through alliances and councils are old. And the next page over, under Anishinaabe leadership, Dr. Boaker states, as legal scholar John Burroughs has noted, Anishinaabe histories are a potent sense of law. They model governance best practices and demonstrate through allegory how consensus-based consultative decision-making work. Anishinaabe oral histories consistently model consultative and consensus-based leadership models. That's how leaders are supposed to make decisions. Tab 8 of our condensed book. Tab 8 is a excerpt from the testimony of Elder Fred Kelly. And on the first page there at the bottom, line 23, it works in this way that, for instance, in our world, there is really no leader in the concept of a commander. The headman, the chief, or anybody like that is honorably the first among equals, but he shares or she shares that responsibility with the people, which means consensus. So a leader then is a consensus builder and echoes that and represents that forward. And rarely, if I have ever seen one, I cannot recall of anything under Anishinaabe law where one single person has unilaterally signed away the rights of other people. So again, the importance of consensus. And finally, just tab 5 is the excerpt from the testimony of Heidi Stark. And I'm at page 79 in the upper right-hand corner. Oh, sorry, page 80. And this is actually her cross-examination. And at line 18, Dr. Stark, would you agree that decision-making within traditional Anishinaabe communities tended to be consensual? And she says, so I think that yes, political leadership was geared toward a consensus model. But again, how we think about, like, there's lots of different meanings attributed to this idea of consensus. And again, for the Anishinaabeg in the mid-19th century, there was extensive practices around deliberation coming to a shared mind. And this is critical, her next statement. So it didn't necessarily mean that every person had to have the same view, but they would agree on the kind of approach that would be taken in particular matters. So it was aimed towards kind of collective agreement towards how to proceed. And the next question, would you agree that one manifestation that you described in Anishinaabe leaders would be to lead by persuasion and example rather than compulsion? And she says, yes, I would agree with that. So it is key to the Anishinaabe that the parties meet, engage, and try to build consensus. To do that, you have to be able to engage in discussion, debate, compromise, give and take. The Anishinaabe are skilled consensus builders. That's a central ethos of their systems of law and governance. At one point, the Crown were also skilled consensus builders, at least good enough to maintain the treaty relationship for 100 years. But when the Supreme Court of Canada directs the parties to return to the council fire and rekindle the perpetual relationship that the parties envisioned, this is what is needed. The Anishinaabe need their treaty partner to engage with them in a meaningful and knowledgeable way. This is fundamental to a healthy relationship. It's fundamental to any relationship. And I want to point out that before I leave the issue of process, that the particular circumstances, well, I would say sort of the unique and peculiar circumstances of this review have the potential to sort of skew what we say is the relationship between process, outcome, and the exercise of Crown discretion. So, you know, here we've had litigation, and then we have a court-ordered engagement session, and then we have litigation again, and the litigation is very focused on the exercise of the Crown's discretion. But that can make us forget that in the healthy treaty relationship, the outcome would ideally be by agreement. Mutual agreement is what would be most consistent with a process which embodies Anishinaabe principles. And the Supreme Court of Canada recognized that under the treaty, negotiated resolutions are going to be the best ones. So we say that any exercise of Crown discretion that is not the product of consensus, that imposes a result on the Anishinaabe treaty partner without their consent should be immediately a bit suspect. And this is why we argue that if the Crown fails to persuade its treaty partner through reasoned discourse and persuasion that its proposed result is honorable, then it should bear the burden of demonstrating to the court why its decision is honorable. Now, I think definitely Canada, I think Ontario too, argue that the onus is on the Anishinaabe in this regard. But as we set out in our reply, starting at paragraph 22, we say placing the onus on the Anishinaabe to prove the Crown's conduct is dishonorable would just exacerbate sort of deep and structural power imbalance that has resulted from the cumulative effects of the Crown's dishonorable conduct. The Crown at this point holds sort of all the de facto control, including the information needed to assess things like the value of the wealth generated. So the Supreme Court of Canada at paragraph 308 was clear that the court should focus on the justification of the Crown's determination. And we say that imposes the burden on the Crown to demonstrate how its process and decision meet the standard of an honorable treaty partner. So the Crown has an obligation to relearn those Anishinaabe protocols, to commit to them, and to engage with its treaty partner in a meaningful way that is aimed at achieving consensus. If that fails to happen, the Crown must come to the court, first to its treaty partner, and if its treaty partner wants to go to court, to the court, to demonstrate that notwithstanding that it was a unilateral decision, unilateral action usually being an anathema to the treaty relationship, nevertheless, it is still honorable conduct.
So it could be honorable conduct.
The Crown needs to demonstrate to the court that notwithstanding that it was unilateral, it is still honorable conduct. That's their burden to demonstrate that to you. If you're not persuaded it was honorable, then they can't proceed with it. Then you can substitute your own decision, send them back, whatever remedy you decide. But they have to persuade you that notwithstanding that their Anishinaabe treaty partner doesn't agree, you should still find that it's honorable. And because we've all been so focused on this review, it seems like that's the common way to proceed, but it shouldn't be. It should be unusual.
It should be what?
Unusual, because they should be working towards consensus. My next point, and the last major point that I want to make, is about the importance of deep engagement by the Crown with the Anishinaabe legal principles. And we start this discussion at paragraph 56 of our factum. And we say that transparency by the Crown and demonstrating a deep engagement with Anishinaabe principles is necessary to overcome what we say is the institutional deficit in the Crown's understanding and to rebuild the trust that must animate the treaty relationship and has currently been damaged. We say, and I think I just said this in the other context, the Crown must be able to demonstrate to its treaty partner, as well as the courts if necessary, that its decision is consistent with constitutional constraints. And we say that includes demonstrating that its decision is consistent with the principles of respect, responsibility, reciprocity, and renewal. We agree with what Mr. Bass said, that it is, with respect to my friends from the Crown, absurd to suggest, as Ontario does, that it has expertise in these principles. While the decisions of the courts in these cases are a good start in understanding these principles, it is only the beginning. If the treaty had worked as the Anishinaabe expected it to, through regular meetings, the Crown and the Anishinaabe would have discussed how these treaty principles would apply as the economic, fiscal, environmental, cultural, social, political, and technical circumstances changed. The parties would have continued to develop and evolve the body of intersocietal law that governs the treaty. And they would have done so in a way that furthers the purpose of peaceful coexistence, enabling the parties to thrive as equals in a mutually respectful and harmonious manner. The Crown would have continued to increase its understanding and knowledge of these principles generally, and the parties would have worked out between them, with the assistance of the courts, I guess, if they needed it, how they specifically applied in the myriad of circumstances that now must be addressed under the treaty. But none of that happened. And now we say the Crown does not only not have any expertise, may have been too many negatives there, but the Crown doesn't have any expertise. It in fact has a serious deficit in its understanding of Anishinaabe principles and protocols in comparison to the Crown's approach in 1850, when it exhibited at least a functional understanding of both of those things. Now, the Supreme Court of Canada said at paragraph 290 that it was important for the Crown to provide reasons with respect to its decision so that the court could pay respectful attention or careful attention to the manner in which the Crown exercised its discretion. Now, the Crowns, in their factum, note the similarity between that and what the court directs a court to do on a reasonableness review in Vavilov. And for all the reasons I've said, we disagree that it's a reasonableness review here. But nonetheless, it is critical that the court, and we say more importantly, the treaty partner, understand how and why the court made their decision. This is because of the fundamental relational nature of the treaty obligation. So we say in these circumstances, the Crown has to demonstrate to the treaty partner that it has wrestled with the applicable principles and has applied them. We say this requires the Crown not just to listen to the Anishinaabe, but to engage with them about what the principles mean, to learn from them, to understand, try to understand the principles, to say back to its treaty partner what it understands those principles to mean, to be open to learning more about them, than to take them to heart and to modify their behavior in a way that incorporates those principles. Because as Doctors Stark and Bohacker say, a treaty is transformative. It's not just business as usual. Now let's think about how we can say it's consistent with the Anishinaabe treaty principles. And in this regard, I want to spend a little bit of time and about what has been written about the obligation to learn about Indigenous legal orders. I note the time, I think there is a realistic chance that I will be done by 1 if we continue on. But if
I don't interrupt you.
well, there is that. But I'm happy to take a break now.
Tracy, you good? Or Taylor, you good? So let's take a crack at it.
Okay.
Sorry. And all the rest of you.
So again, I will resist reading the entirety of these articles to you, but they are all very relevant to what we're discussing. I want to start with tab 12, which is Chief Justice Finch's paper on the duty to learn. And this, of course, is a paper about the obligation to understand Indigenous legal orders. It was given, I think, in the context of a conference about making space for Indigenous legal orders, which comes up later in it. And I just want to take you to a couple passages that I think it's important to keep in mind. One is on the second page, 2.1.2, where they quote from Professor Burrows. It says, in practice, there are enormous risks for misunderstanding and misinterpretation when Indigenous laws are judged by those unfamiliar with the cultures from which they arise. The potential for misunderstanding is compounding if each culture has somewhat different perceptions of space, time, historical truth, and causality. So that's just a warning to make sure that you are giving enough room to the Indigenous treaty partner to fully explain the perspective, which is perhaps more different than would first be understood. He goes on about this a little bit at page, I'll use the page numbers in the top right corner, page 131. He says the evaluation of Indigenous legal principles will be especially fraught with danger if the interpreter does not recognize the cultural foundation of knowledge and fails to acknowledge his or her own bias. He talks, starting at page 132, about obstacles to understanding Indigenous legal orders, including the fact that they may be taken out of context, that when you translate them to text, they may lose what they were originally supposed to say. At the bottom of page 134, he talks about internal distortion, about how we all have our own context and point of view. It's deeply ingrained, and sometimes we don't even recognize it's there. We have to be aware of that when we're coming to understand Indigenous legal orders. He talks about the importance of not just learning a new order, but forgetting your own, forgetting some of the principles that have constrained your way of thinking. Paragraph at page 135, paragraph 39. He says, the task for which we are attempting to equip ourselves is not only that of making space within the known landscape, as the central question of this conference presupposes, it is a matter of attempting in good faith and as respectfully as possible to enter new landscapes, legal, ethical, and cultural. A deeper understanding of the web of relations between the foundations of the legal system and law itself may only be gained by shared experience. So it's a shared experience. You have to do it together. The previous paragraph 38, he said talking about ways to find space for the current legal landscape and the pre-existing legal landscape. It's not a one-way street. Paragraph 40, in the process of entry, the important qualities of mind to adopt or to aspire to are respect and receptivity. To enter a landscape empty-handed is to do so with all senses opened, sharpened by a sense of its vastness, its permanence, and its inseparability from the larger world. Respect in this context is simply the acknowledgement that we are all human, we are all different, and no matter how important they may be, our values cannot be treated as absolute and exclusive. We all have much to learn to each other. Paragraph 44 on the next page, this is where he talks about the importance of the inversion of the question. A crucial part of the process must be to find space for ourselves, and that by that he means the Canadian legal order, as strangers and newcomers within the Indigenous legal orders themselves. And he says, finally, through all stages of this process, we must retain a sense of humility. For non-Indigenous lawyers, judges, and students, and I would say the Crown, when it's discharging its duty to act in accordance with Anishinaabe Treaty principles, the awareness is not restricted to recognizing simply that there is much we don't know. It is that we don't know how much we don't know. So coming to the project of understanding what the Indigenous legal orders require of an honorable treaty partner is one that requires openness, humility, and a willingness to engage. And I'll just spend a little bit less time on the next article, which is, of course, by Chief Justice Bauman, called A Duty to Act. And at paragraph 7, he says, as we find space for Indigenous legal orders, we must look to Indigenous peoples to determine what that space will look like. Senator Murray Sinclair has said that a process of reconciliation, including legal reconciliation, that does not include an Aboriginal perspective and approach will be doomed to fail. I couldn't agree more, and if I may, I would add that beyond inclusion, the Indigenous perspective should be prioritized and centered. In embracing that approach, our Western liberal life world must be supplemented and maybe in some circumstances supplanted, and our assumptions about law and equity questioned. We must unlearn and, to be frank, defer. We must hold space for hard conversations and be willing to be wrong. If there's anything that the last 200 years of Canadian Indigenous relations has taught us, it's that our jealous need for control is destructive. He goes on to talk about the impacts of what has happened when the colonial system was forced on Indigenous people, saying the result was catastrophic. Now is the time to do what we should have done when we arrived here as uninvited guests. Demonstrate that we care enough to discover and learn and to act responsibly within the matrix of Indigenous customs, tradition, and protocols. Now is the time for humility. And finally, if we go to paragraph 14, he makes the note that just like the common law, Indigenous legal orders are not frozen in time. Traditions evolve and build on what preceded them. Indigenous laws will persist so long as they develop and remain relevant over time. And while origins of law are important for context, the focus is on the law's current understanding and application, separate from origins. While traditions may be inherited from long ago, we honor that legacy, but do not view them as historical. There's no need to fight the fog of history. Indigenous law is living and is alive. So we say that the Crown needs to adopt this approach of humility and openness and come to the council fire and learn about the treaty principles. And while it is of course essential that the Anishinaabe lead the Crown in its renewed education on Anishinaabe law and the principles that govern the treaty relationship, The Crown also has an obligation to educate itself. The burden isn't entirely on the Anishinaabe. The Crown must learn what it can, and when it comes to meet its treaty partner, it must discuss what it has learned. It can't just listen. It must share with the Anishinaabe its understanding, talk to them about whether the Crown's understanding of its treaty obligations is correct and honorable. It must be a collaborative and participatory process. So part of the renewal required by the treaty partners is that the Crowns demonstrate a genuine commitment to both learning the principles and protocols of the treaty relationship and unlearning the deeply colonial approaches that continue to stabilize that relationship. We say that finally, in its decision, the Crown must demonstrate why its determination is consistent with those principles. As we say at paragraph 62 of our factum, demonstrating a deep engagement with these principles is a necessary, though not sufficient, component of ensuring that the Crown's decision is honorable. The court, of course, is also required to review whether the substantive outcome is consistent with the honorable standard. But by ensuring that the Crown understands and articulates its basis for saying that its processes and its decision are consistent with these Anishinaabe principles, the court is safeguarding what we say is the respectful and deliberative approach to decision-making that's required by the treaty. Requiring the Crown to carefully articulate its understanding of the principles and why it thinks its decision is consistent with them will allow both the court and the Anishinaabe treaty partner to assess the Crown's decision. Without knowing why they think it's consistent with that decision, it is difficult to review it for honorableness.
Let me just get that last point, please. Your last proposition is without knowing why the Crown thinks their decision is consistent with, is that what you're saying?
Yes,
With Anishinaabe protocols.
with the standard of a honorable treaty partner generally, but specifically with respect to the Anishinaabe treaty principles.
And you say that's without the court knowing that? Then
Well, the Anishinaabe treaty partner needs to know it. That's part of a relationship, is making sure they shouldn't be left wondering why the Crown has such a different understanding than they do, or in what way the Crown has a different understanding. And they won't be able to engage with the Crown and correct that understanding if they don't know what it is. And then, of course, it's important if there's a court review for the court to be able to understand that. The Crown doesn't get to decide what the Anishinaabe treaty principles are, but in order to demonstrate to the court that why the court should find that the Crown's decision is consistent with those principles, the Crown has to articulate why it thinks it's consistent with those principles. And that's, again, the process of having the Crown articulate that will facilitate what should have been the party should have been doing all along, which is coming together, discussing the principles, developing the intersocietal law, applying them in a myriad of circumstances. And that takes more than listening. So those are my submissions on process. And I just wanted to address briefly those two other matters, which we address more fulsomely in our factum, but which may not be as contentious now. So one is the question of measuring the wealth of the territory. it is the RHT Anishinaabeg's position that any honorable interpretation of the treaty promise to share the wealth must define the wealth to be shared as capturing all the benefits and revenues from the treaty territory that are captured by the Crown directly or indirectly. So we explain in our factum, section F, why it would be improper, inconsistent with the Anishinaabe Treaty principles, dishonorable for the Crown to have taken jurisdiction over to purport to have taken jurisdiction over the treaty territory to determine what revenues are going to be collected, how they're going to collect them through these different revenue streams, such as taxes or resource rents or anything else, and then only take for itself the benefits in all these different forms, and then only share with the Anishinaabe one stream of revenue, which is the resource revenues. That would be dishonorable, we say. But our interest in this is clearly about going forward. And our concern was that when the Crowns articulated in their decision letters why they chose resource revenues, we were concerned that they weren't limited to the purposes of providing compensation. We were concerned that they were saying it's a matter of treaty interpretation that might apply to us going forward. Only NCRRs could trigger the obligation to have to decide whether to increase the annuity, or that only NCRRs were to be taken into account in terms of the wealth to be shared. I think in both of their factums now, the Crowns have said that going forward, it is open for the parties to argue whatever they want to about what's required by the treaty. And so I think we're all in agreement that we don't want you to say anything that would preclude the ability in the future for us to argue that as a matter of treaty interpretation, our broader view of revenues is what's required. In each case, some way of measuring the wealth, there may be a different appropriate way of measuring the wealth. There may be different experts who do it a different way, but it should be open to us to argue that something besides NCRRs is appropriate. And I think that Canada's.
If I can just jump in, and you say that very specifically, notwithstanding that that this court may make a comment about what approaches are honorable for a determination of past benefits.
It would be if in fact you're going to make a determination about what the treaty requires as a matter of interpretation, and not just with respect to the past, then we would ask you to please have careful regard to our section F, where we argue that you need to take into account some way of accounting for the revenues, all the revenues that the Crown receives from the territory.
And you say that being careful not to make any
if you were to set
any interpretations of the treaty for the purposes of going forward is consistent with what the Crowns are saying.
If you interpret the treaty as adopting the position that we just set out, that any honorable interpretation needs to be based on a way of quantifying the shareable wealth as including all of the revenues that the Crown has received. We have no objection to that being a general principle, right?
We could probably get an agreed statement of fact, I suppose.
But and that's why we're here, because if you are going to make any ruling that's going to go forward, we want you to consider our argument on that. But we can imagine ways that you can decide what's appropriate for past compensation and not have to say anything about going forward. I think the Crowns are content for you to do that. We were concerned they were going to urge upon you a way of restricting the revenues to NCRRs that was going to affect us in the future. I think they are now saying that they're content for you to make your decision based on just the past. If I'm wrong about that, I'll address it and reply. We'll hear from them. The other point was that we have a section in our factum about what the court should not take from the RHT settlement. And specifically, we say the court cannot take from that the RHT and Anishinaabe agree with any particular part of what the Crown says that goes into the calculation of what's payable under the annuity. It's a global settlement. You can't take anything from what the Anishinaabe believe is the appropriate way to do this on a going forward basis from the settlement number itself. And we were concerned that Canada's reference to some of the expert reports and the number and the similarity with what was here was a suggestion that you should infer that we think it's honorable that one of the big three be dealt with in a specific way. And we're saying you can't infer any of that. And Canada has agreed with that. So I don't need to spend much time on that.
Sorry, Canada does agree with that, or you say Canada references certain that there are inferences to be made from the settlement?
Canada agrees that you cannot infer anything about the RHT Anishinaabeg's position on any of these issues that are before you now with respect to resource revenues or share or bring forward or anything like that. You cannot infer what the RHT Anishinaabeg's view would be if they were having to litigate that from the fact that they settled for a certain number. Canada agrees you shouldn't draw that inference.
Thank you.
So just in conclusion, the RHT and Anishinaabe say that both this treaty and the Robinson-Huron Treaty are and always will be ongoing relationships that are fundamental to the Constitution of this country. It is the basis for Crown sovereignty and jurisdiction. It is, as the SEC said, an alliance of equals. Now, I think it's important to understand, I mean, one thing we talk about in our reply argument is that when you read the Supreme Court of Canada's decision, it appears at first glance that there's a real tension between sort of two different frameworks. The framework of constitutional rights and the framework of the deference that's shown when the Crown is making decisions about distributing resources because of the polycentric nature of that. And we say the key to resolving that is to realize that we're in a sui generis state here, that the court's responsible for ensuring that the relationship is conducted on the basis of certain principles. This case, unlike any other that involves Crown distribution of resources, You have to remember the unique situation here. The Crown only has access to those resources because of the promise it made to the Anishinaabe. Calling it the distribution of, the allocation of Crown resources is a little questionable. They're the Anishinaabes' resources that they shared with the Crown on the basis of this promise. It's a unique fact situation. It requires the court to supervise the Crown's decisions in a way unlike many distributive decisions under statute. As I said, the Supreme Court of Canada emphasized that the treaty is an alliance of equals. It can't privilege, the law can't privilege one treaty partner's vision of what is honorable. And ultimately, the RHT and Anishinaabe are here to ensure that nothing in this decision prejudices our ability to implement the treaty in a manner that restores a healthy, respectful treaty relationship. The Crown needs to understand that it is required to engage honorably with its treaty partner to try and achieve consensus on what the treaty requires in a modern context. This involves more than listening, requires learning, engaging with an open heart and a spirit of humility. It includes having careful regard to Anishinaabe protocols and principles that first welcome the Crown into this relationship of trust on the Anishinaabes territory. And we say when the Supreme Court of Canada said the parties must return to the council fire and rekindle the perpetual relationship, they were directing the parties, but especially the Crown, to meet and engage honorably in the deliberative and consensus-based processes, which for a very, very long time animated this ancient system for repairing and renewing the treaty relationship. And it's the court's role to consider whether that's been done.
I have a question.
Yes.
I don't think you have addressed parity in any way.
No.
The references you have made to polycentric considerations that the Crown may bring into its decision-making, to a great extent, one might say from the decision letters, to a great extent, include parity. And particularly Ontario speaks to the importance of parity as between the Hurons and the Superiors. And it seems to me if the RHT is here as intervenors with a concern about going forward, they may have a concern about the role of parity in the considerations that the Crown makes, because one day it may be that the Crown reaches a resolution with the Superiors first. And so, given that you have thought it important to caution the court about findings that may affect the future, does the RHT have something to say about the weight of parity in the considerations going forward?
So let me answer the question this way. And I'm done with my presentation. And what I'm going to do is I'm going to answer your question, then I'm going to if possible, I'd like to, because I wasn't anticipating that question, and maybe I should have, I'd like to spend 5 minutes consulting with my team about that. But I don't have any instructions to make any submissions on the importance of parity or the non-importance of parity. But you have the Anishinaabe evidence, including the evidence of Fred Kelly that I took you to, about not giving away anybody else's rights. And you have the evidence from Dr. Stark and Boaker about how people retain their autonomy. So no, I don't have any specific submissions to make to you on that point, but the evidence about that is there before you.
And do you want 5 minutes or do you want?
No, I think that's all I can say about that.
Okay. And that's,
And those are my submissions. To any other questions? Thank you.
thank you very much. All right, is that our day? Is that our day?
Yes, that would be our day.
Okay, well then. And that's our day. So we'll break now until Tuesday at 10. And Mr. Bass may be sending out, there have been various announcements, but you may be sending out.
I have actually, in fact, already sent out an email both to the court and to the parties. I'm happy to mention it here as well. There'll be a ceremony, a sweat ceremony hosted by BNA at their location at 150 Grandview Road on Monday, starting promptly at 3, and followed by a feast, which will be at the Fort William First Nation Community Center at 6 p.m. that day. And I've already confirmed with council that a representative from all of the council teams will be in attendance.
Thank you very much. And I believe Ms. Lewis is sign languaging something to
I've
me.
spoken to all council about a group photo on the stairs right now. So perhaps this is a good time to.
All right, we'll break to the staircase. So thank you very much. Be well, be safe, and see you next week.
This court is adjourned until June 10th, 2025 at 10 a.m.